Welcome once again to Lehto's Law. Here's Steve Lehto.
Joshua is an attorney in New York, and he sent me a note and said, Steve, I've been following a case that you did a video about a while back because I found it as interesting as you did. And it was the case where I talked about how in Massachusetts, if the government comes into possession of your car and they wind up auctioning it for whatever reason, unpaid tickets, or it gets impounded for some reason and you don't recover it, that they will auction the car and sell it without notifying lien holders of the car, okay? And that's a problem. And now the interesting thing is that I misunderstood how the law worked in the first place, and it was worse than we thought in a really, really strange way, which we'll get to. But Joshua said, Steve, but here's the deal. They just fixed it in court, and they fixed it the way you'd expect. And that is the lien holder in a particular case, which was involving a Honda motor vehicle, sued and said this law is stupid. And the U.S. District Court, District of Massachusetts, agreed and said this is a stupid law and struck it down. So again, what happened was American Honda Finance Corp., I'll refer to them as Honda here, although it's Honda Finance, initiated this action against the city of Revere, alleging that the policy of allowing towing companies to auction a vehicle without notifying all interested parties deprived Honda of its due process rights under the Constitution. So Honda finances a car for a consumer. The consumer takes possession of the car and is making payments to Honda Finance. If you look at the title to that car, it'll say it's owned by owner, but a lien is in place for Honda Finance. So before that title can change hands legally in most instances, you've got to take care of that lien with Honda Finance and take care of the owner. But the way the law was written in Massachusetts is that if the government took your car, they didn't have to notify the lien holder. They could simply auction it and go with it like that. So Honda Finance sued, and then they filed a motion for summary judgment. Summary judgment is where you tell the court, in essence, that we can decide the case now. There's no facts in dispute. Right now, based on the pleadings alone, you can make a ruling. And the court looked at it and said, yeah, we can. And they made a ruling. So no one argues with the facts of the case. The car was seized by the city of Revere for some reason, and no one's questioning the legality of the seizure. And then the vehicle was auctioned, and no one notified Honda that the vehicle was going to be auctioned. Vehicle got auctioned. The city of Revere got paid their money. The towing company got paid their money. And here's the weird part. I did not know this before. The leftover money went to the owner of the car. So up until this case came down just a few days ago, if you were smart and figured this out, you could go to a dealership and buy a car, borrow all the money to buy the car, take the car and illegally park it someplace, let it get seized and towed and seized, auctioned, and the towing bill would get paid, the parking fine would get paid, and they send the money to you. And of course, why would they send it to you? Oh, I'm sorry, that's what the statute says. So the statute we're talking about, if you want to look it up, I looked it up yesterday and read it. It's hilarious. Massachusetts General Laws, Chapter 255, Section 39A, does not require the city or Mario's Towing to contact the lender, which is the lien holder, despite their interest in the vehicle. And they tell you to go look it up. If you don't believe it, it's there. And I looked it up, and I believed it. So in this case, the towing company advertised the vehicle for sale and sold it on July 30th, 2017 for $15,000. Now, what's interesting is NADA showed the value of the vehicle at $16,092. And interestingly, the court says Honda could have received that amount had it been allowed to sell the vehicle itself. NADA Blue Book values are averages. For all we know, this vehicle was in bad condition. But the parties stipulated to that figure. So parties apparently said, well, yeah, the vehicle could have sold for $16,092 instead of the $15,000 for which it sold. But following the sale, Honda's lien was not recorded with the vehicle's new title through the Massachusetts Department of Transportation. So the person who bought the car at auction got it with a clean title, unencumbered, as we say. As a result, the sale and retitling of the vehicle effectively extinguished Honda's property interest and ensured that Honda would not recoup any proceeds from the sale of the vehicle. So therefore, all they were left was with an unsecured loan against the original borrower. You might say, Steve, why don't they go after that person? Well, they could, but the point is that if they had a secured loan, they were in a better position than having an unsecured loan. That's why you secure a loan. Now, I know that most people don't tune in going, I hope Steve talks about security interest today. Boy, that sounds like fun. Article 9 of the UCC. But the point is that if the lenders can't count on the security interests being intact, they'll stop lending money. So, and you might say, well, Steve, that only affects one state. Maybe they can stop lending in Massachusetts. Except for, let's suppose you live in New York and you decide to take a vacation in Massachusetts. And while you're there, your car gets seized for some reason and it gets sold at auction. It doesn't matter that your car came from New York or Ohio or Michigan or Hawaii. You drove it over. The point is the car gets auctioned. They don't notify the lien holder, which is craziness. So the interesting thing is that Honda Financial said, look, this is a violation of our constitutional rights. Depends on how you want to look at it. But there are a whole bunch of different sections of the Constitution that say that you can't take stuff from people without compensating them for it. The city of Revere actually made the argument and said, well, you can't sue us. You should be suing Mario's Towing. Mario's Towing says you shouldn't be suing us. You should be suing Revere. Oh, boy. Due process claims invoke a two-step analysis. The plaintiff must have a protected property interest recognized by law, and the plaintiff must demonstrate that the defendant deprived him of the property interest without constitutionally adequate process. Honda's perfected lien gives it an enforceable property interest in the vehicle, thereby easily satisfying the first element of having a protected property interest. In case you're curious, a perfected lien is what we're talking about here. And a perfected lien is a term of art. And if I sell you something, a widget, and you don't have the money to buy it from me, and I lend you the money to buy the widget from me, it's called a purchase money security interest if I say that I'm going to lend you the money to buy this thing from me, but the thing you're buying from me will act as collateral for the loan that you're taking out from me. Not as complicated as it sounds. Purchase money security interest. So the purchase money that I'm lending you is secured with an interest in the thing I'm selling you. And then, of course, what happens quite a lot of times is dealerships sell the car and then assign that paper to somebody else. So they refer to it as a perfected lien if, in fact, it is done in such a way that other people will be put on notice of it should they come into contact with a situation. And in the most common example, it's with automobile titles. So most states, as far as I know, have a process where if you title a vehicle with a lien on it, the state will put the lien information on the title as to who the lien holder is. So that when you go to buy a car, you don't need to look it up. You simply look at the title and go, oh, there's a lien holder. There's a lien holder. So it puts anyone on notice who's acting reasonably that there is, in fact, a lien holder. And that protects the interest of the lien holder. And as I pointed out earlier, this is perfectly sensible in an economic sense because it allows lenders to have more safety with the money they lend. So they lend money knowing that if all else fails, we can go back and get the collateral. So this wacky law in Massachusetts that said, oh, we can sell the vehicle without notifying the lien holder, because what they're basically saying is, if you had told us the car's about to get auctioned for an unpaid parking ticket and a towing bill, we'll pay it and repossess the collateral and sell it at auction. So the crazy part, like I said before, is they weren't notifying the lien holder, and they were then sending the proceeds, if there was an overage, to the owner of the car. So they point out that Honda had a property interest and that there was not adequate notice to the parties, which is what due process requires. The essence of due process is the requirement that a person in jeopardy of serious loss is given notice of the case against him and has an opportunity to meet it. And that's actually a pretty low standard. Notice and an opportunity to be heard. That is, you know what the problem is, you know what the claims are against you, and you have the right to contest them or protect them or whatever it might be. So, as the court writes here, if the government does not provide property owners with any sort of notice or provide a hearing prior to seizing the property, that is a per se violation of the interested party's due process rights. And it takes the court, I'm not making this up, I think 17 pages. Good thing my printer does two sides because I can save paper that way. But the opinion is, in fact, 17 pages long. And on page, actually 18, on page 17, the court writes, As the parties do not contest the value of the vehicle upon the date of advertisement, Honda would have likely received that amount had it been allowed to sell the car. Thus, the court grants damages in that amount, $16,092. Honda's motion for partial summary judgment is granted. Revere's cross motion is denied. Revere actually argued, said that their law made sense. And, they've got to do that, unfortunately. And there's nothing worse as a lawyer, be sent into court on a losing case, stand in front of a Supreme Court or Court of Appeals or a federal court and have to make an argument that's stupid. But this law was crazy. And like I said, it was even crazier than I thought, because I thought previously that the government kept the money. That's what Michigan would do, right? Massachusetts was sending the proceeds back to the titled owner of the car. So like I said, you could borrow the money, let the car get taken, and just wait for the windfall to come, which makes no sense. So the law got struck down. Joshua sent it to me, and I'm glad he did, because I would have found out about it eventually, but not as quickly as when he sent it to me. And if I can find page 1 here, which I probably can, given a few more minutes, who's got that kind of time, I can tell you about the name of the case, and those of you with the gumption to do so can look it up. But the case is, like I said, federal court, Massachusetts, American Honda Finance Corp. Versus the city of Revere, civil action number 19-CV 10266-ADB. So 19CV 10266-ADB, and that is the memorandum and order granting plaintiff's motion for summary judgment on the constitutional issues, and that law has been struck down now. So what this means is that in the instances where this has happened in the past, if it's happened in the past, it's going to be a slam dunk for them to get their money back. Going forward, they've got to stop doing this. The municipalities in Massachusetts have got to stop doing it. And they'll have to rewrite the law in some way to make sense, which the way it should have been in the first place. So Joshua, thanks for sending it along. Questions, comments, put them below. Otherwise, I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. With the rise of self-driving vehicles, it's only a matter of time before we get a country song where a guy's truck leaves him too.